Hey guys, this is Jules with True Crime Reactions. Disclaimer. Everything stated in this video is my opinion and my opinion only. And just like everything else in these cases we discuss here on this channel, everything is alleged. Okay, so we've been going through the huge file drop that came out of the Idaho 4 case from the state's side, and we've gone over so much to the point to where we know for a fact that they're definitely doubling down on wanting to seek the death penalty, but they did remove one of the aggravators from the reasoning for why they want the death penalty. Now, what we went through in that video was the amendments to them seeking the death penalty and also the response to the defendant's motion to strike the felony murder aggravator. They really just responded with stating, hey, we're kind of already doing what they are like asking us to do, so you should deny this because it's basically invalid now. It's not like an actual denial or an objection. Now, there's 4 other aggravators. There's 4 other factors to the death penalty that the state is keeping on for this entire situation. And now we're going to go through their responses, their objections to all of them in order as they were filed by the defense. So we went through the seeking death penalty and the felony murder aggravators first because they seem to be the most prominent ones, the most important ones, and in order. Now we are going to go through the future dangerousness aggravator. Okay, so this is the objection to strike the future dangerousness aggravator, and it states, comes now the state of Idaho by and through the Latah County prosecuting attorney and hereby objects to the defendant's motion to strike the future dangerousness aggravator in this case. For the following reasons, defendant's motion should be denied. Argument. To defendant's credit, he acknowledges from the outset that his motion to strike the future dangerousness aggravator, often referred to as the propensity aggravator, which is the last one on their list from the ones that we read a couple of videos ago, flies in the face of well-established precedent. Specifically, defendant acknowledges that the Idaho Supreme Court and the United States Supreme Court have upheld the constitutionality of considering propensity as an aggravator in capital cases. And they are citing State versus Creech and then Jurek versus Texas, which they have mentioned a few times. However, defendant dismisses with a figurative hand wave the Idaho Supreme Court's decision in Creech and the United States Supreme Court's holding in Jurek versus Texas, both of which are binding in this court. Both of which are binding in this court is probably what it's supposed to have said, as problematic, and plows ahead with 3 arguments in support of his motion. First, he asserts that the propensity aggravator fails to narrow the class of death-eligible defendants. Second, he contends that the propensity aggravator is impermissibly vague. Finally, he claims that the propensity aggravator is irrelevant to culpability and therefore cannot be an aggravator. This court cannot overrule the Idaho Supreme Court. That's A. As elsewhere in his briefing on the death penalty, defendant asks this court to enter a ruling contrary to a specific holding of the Idaho Supreme Court. This, of course, the court cannot do. The Idaho Supreme Court ambiguously set forth its authority in State versus Guzman. To this court falls the obligation to be and remain the ultimate authority in fashioning, declaring, amending, and discarding rules, principles, and doctrines of precedential law by application of which the lower courts will fashion their decisions. This court has been and remains the final arbiter of Idaho rules of law, both those promulgated and those evolving decisionally. I feel like we read those words in the last video that I recorded. State versus Guzman, again from 1992, having admitted that binding appellate case law forecloses his argument, defendant's motion should be denied on this basis alone. Now B. The propensity aggravator appropriately narrows the class of death-eligible defendants. As noted above, defendant acknowledges that the constitutionality of the propensity aggravator was upheld by the Idaho Supreme Court in State versus Creech. There, the court held that the propensity aggravator narrows the class of death-eligible defendants and even provided an example of the type of murder that would not fall within the scope of propensity aggravator. Here, it cannot be asserted that the propensity circumstance could conceivably be applied to every murderer coming before a court in this state. We would construe propensity to exclude, for example, a person who has no inclination to kill, but in an episode of rage such as during an emotional family or lover's quarrel, commits the offense of murder. We would doubt that most of those convicted of murder would again commit murder, and rather we construe the propensity language to specify that person who is a willing, predisposed killer, a killer who tends towards destroying the life of another, one who kills with less than the normal amount of provocation. We would hold that propensity assumes a proclivity, a susceptibility, and even an affinity towards committing the act of murder. Now they're talking about Creech. Ignoring the specific example provided by the Creech court, defendant complains that the Idaho Supreme Court's gloss is a list of synonyms that define anyone who would commit murder as already defined by the legislature and does not accomplish the genuine narrowing required by the Eighth Amendment. Unfortunately for the defendant, one's personal interpretation or belief about the Idaho Supreme Court's holding in Creech is irrelevant to this court's determination. Meaning they don't give a damn. They don't give a hot damn what they're trying to say. And then it says to C. Guzman, holding that the Idaho Supreme Court remains the final arbiter of Idaho rules of law. And then C, the last one, is the aggravator is not impermissibly vague. Here again, defendant acknowledges that the law is not on his side. Under his heading with IC 1925159I is impermissibly vague. Defendant next writes that the United States Supreme Court held that future dangerousness was not vague as it was something judges had to do all the time. And they claim that in the motion to strike the future dangerousness aggravator whenever the defense was also speaking about Jurek versus Texas from 1976. Defendant is correct. The United States Supreme Court upheld the constitutionality of a future dangerousness or propensity aggravator in Jurek versus Texas. In Jurek, the court addressed an argument similar to the one that defendant poses to this court. In the Texas statutory scheme at issue in Jurek, jurors in a capital sentencing proceeding had to answer 3 questions relating to aggravation in the affirmative. One of those questions was whether was a probability that the defendant would commit criminal acts of violence that would constitute a continuing threat to society. On appeal, the Jurek defendant argued that it is impossible to predict future behavior and that the question is so vague as to be meaningless. That's not true. It is very much possible to predict future behavior. Sorry, not sorry, but that's an incorrect statement. Rejecting that contention, the Jurek court held that prediction of future criminal conduct is an essential element in many of the decisions rendered throughout our criminal justice system. Yeah, especially if there's a history of escalation. It's kind of proving itself relevant in the process. And that what is essential is that the jury have before it all possible relevant information about the individual defendant whose fate it must determine. Accordingly, the court concluded the Texas statutory scheme did not violate the Constitution. The court also explained that by authorizing the defense to bring before the jury at the separate sentencing hearing whatever mitigating circumstances relating to the individual defendant can be adduced, Texas has ensured that the sentencing jury will have adequate guidance to enable it to perform its sentencing function. Defendant then argues that the propensity aggravator should be struck for the sake of clarity to the jury, arguing that there is potential for confusion where certain types of mental disorders could be taken as both aggravation and mitigation, arguing that practically speaking, every case where a jury is asked to find a person is likely to pose a threat to future dangerousness will involve underlying significant disturbances in that person's mental functioning. So he wants it removed so that the jury doesn't look at it as a negative towards him when it comes to them determining whether he's guilty or innocent. I kind of feel like that's where they're going with that. And I mean, you would have to just really, really explain that to the jurors that this is based on the crime itself and not based on the accused until the accused is proven to be guilty. Because then it'll matter. It'll matter then. But in the long run, it's really just saying that the person who could have committed these crimes is obviously a danger to society. There's no ifs, ands, or buts about that. Defendant asserts that from the Supreme Court's view, a mental illness is a type that renders a person unable to understand the meaning of or reason for it, bars the application of the death penalty, which regardless wouldn't be Bryan Kohberger anyway, because he knows damn well what he's doing. He's a criminal person. So if he is the person who did this, which again, they're doing a shit sorry like job trying to prove it, just plain and simple. If he is the person, this definitely wouldn't have anything to do with him, because one of the big reasons why it's hard for us to believe that it was him was because of all of the education that he does have in criminal justice, like the whole criminal thing. So they definitely couldn't use that. In support of this argument, defendant cites to Ford versus Wainwright from 1986, but this case is wholly irrelevant to the defendant's argument. Ford versus Wainwright dealt with a defendant who had appeared to be intellectually normal at the time of his conviction and sentencing to death. Ford developed a severe mental illness in the years that followed, displaying symptoms of schizophrenia that included referring to himself as Pope John Paul III and claiming to have appointed 9 new justices to the Florida Supreme Court. So whoever that guy is went crazy after the fact. Like basically being in prison probably kind of made him go a little bit crazy, because it'll do that. It will do that. The court ultimately remanded the case for a determination of the defendant's sanity, explaining that it is no less abhorrent today than it has been for centuries to exact in penance the life of one whose mental illness prevents him from comprehending the reasons for the penalty or its implications. So even though he was very aware of everything that was going on at the time that he committed the crime, he had gotten into a mental state to where I guess he couldn't understand that he had done something like that, the repercussions of that, or why he was in the jail to begin with, I guess is what they're saying. In any event, there is nothing on the record that suggests that the defendant in this case has a mental illness of a type that renders him unable to understand the meaning of or reason for the application of the death penalty, which is true. And at this point, they have to reference Bryan because he's the only one sitting at the defendant's table. Nor is there any indication as of this time that evidence of mental illness would be presented at sentencing by either the prosecution or the defense. It better not show up for the defense side, because I'll lose all of my faith in this case if they try to even attempt to go that way, as neither party has yet filed notice under Idaho Code 18207. Accordingly, this argument is wholly irrelevant or alternatively not ripe. Okay, so it wasn't the last one. Now we got the D one. Future dangerousness is a relevant sentencing consideration. I agree. I totally agree. Defendant's assertion that future dangerousness is irrelevant to punishment is without merit. As the defendant himself pointed out in discussing Jurek, the United States Supreme Court characterized prediction of future dangerousness as an essential element in many of the decisions rendered throughout our criminal justice system. Again, when they are looking at somebody's record and they see that they've stolen stuff like 4 times from stores and people's houses, they've gotten busted running away from stealing and doing stuff, and then all of a sudden they get pulled over again, and now it's not just they were stealing stuff and they were on the run. Now there's drugs in the car. They've got some assault charges now pending onto it. It's called escalation, and they look for that because they don't want it to get to the point to where you're going to end up doing something cray, or at least that's how they act. I feel like it's all bullshit. I really do feel like it's bullshit for my own personal reasons with what I've dealt with in life, okay, and am dealing with in life. Escalation and history of things matter. Just because it doesn't matter in this case to who Bryan is doesn't mean that they don't matter as a whole. If this wasn't Bryan Kohberger, okay, if we didn't have 1,001 freaking infinity questions in this case, if they could actually prove to us that it was Bryan, and then all of our thought process completely changed on who we're looking at, would we even be questioning why the state is saying what they're saying? No, the state's arguments here would be more relevant, but because of who they're talking about, it doesn't really add up to him at this point in time, because I agree with these rules. I agree with the state, with what the state is saying here. This stuff matters. Now, I agreed with what they said about how they didn't want the jury to see that as something because it could put a false perception on the evidence at hand and who the evidence is supposed to be pointing at versus where the evidence is actually pointing, if you get my drift. So I understand that part. But to just say, oh, we got to throw all this stuff out, no. You don't. You don't, because that means that all these horrible people that did all these horrible things, that these things were used against to keep them behind bars because it was approved for you, they're going to try some boo-boo. That's how I see this happening with things that change here. And again, this doesn't change my opinion on what's going on with the case, but I agree with the state in the sentiments. Additionally, Idaho's appellate courts place protection of society against the future dangerousness of defendants at the forefront of all sentencing decisions. As the Idaho Court of Appeals explained in State versus Toohill, it is clear as a matter of policy in Idaho that the primary consideration is the good order and protection of society. All other factors must be subservient to that end. Defendant's motion is contrary to settled Idaho Supreme Court and United States Supreme Court precedent. It should be denied. Which again, I am agreeing with the state on their sentiment and their thinking on it. But when it does come to the defendant at hand right now, I don't believe that it should be attached to him, which is also his way of thinking. But I get it. I get both sides. All right, you guys, that's it for that one. The next video is going to be the argument for the HAC aggravator. As always, let me know what you guys think about this argument between the state and the defense down in the comments. If you like the way that I present this information and give my opinion, please don't forget to leave a like on your way out. Subscribe to the channel if you are not subscribed already. And please make sure that your notification bell is set to all so you don't miss any of my rants, reviews, reactions, updates, or deep dives. See y'all.